court is now in session. The Honorable Reese S. Hodge, Chief Justice. The Honorable Maria M. Cabret, Associate Justice. The Honorable I. Arlington Swan, Associate Justice, presiding. God save the United States, the territories of the Virgin Islands, and this honorable court. Please be seated.
Good morning. Good morning, everyone. Okay, we will start with the cases in the order. It's Stephen D. Payne Sr. et al. Versus the 35th Legislature of the Virgin Islands. That's number 126 of 2023. Carolina, are you ready to proceed? Just to get it clearly, I noticed on the calendar it says that Tristan E. Moore is for the appellants and you are for the appellee, but I believe in this case you were the...
We were the plaintiffs under the original.
I understand.
And
Yeah.
we're the appellee under
The appellate. Okay, so we got it right. So anyway, Rolanda, you may proceed.
Judges know me personally. For the record, my name is Joseph Arellano, and I represent the 35th Legislature, successor to the 34th Legislature. And
Why don't you bring the mic down a little bit and try to speak directly into it so we can hear you?
is this better?
Yes.
Okay. I represent the 35th Legislature as successor to the 34th Legislature, and the Honorable Senate President Noel Francis, who is the President of the 35th Legislature, as successor to Donna Fred Gregory, who was the past President of the 34th Legislature. Your Honor, before I begin my argument, I would like to move to have a pre-argument on the issue that we raised on page 1 of our main brief, excuse me, footnote 1. We said to the court, the 35th Legislature said to the court that the issue of the ultra vires, whether or not the legislature acted ultra vires, is not properly before the court, and we continue to maintain that position in our reply brief. Excuse me, and so I would like to present an argument to preclude hearing at this oral argument.
You've made that in your brief, and we're going to hear everything today and decide what we will accept and not accept. So your 15 minutes, do you wish to reserve any time for rebuttal?
Yes, Your Honor. In view of what the court just said, that is going to be a proper subject of argument, we would reserve 7 minutes for rebuttal. Generally, I don't reserve that much, but I will reserve 7 minutes to deal with that issue.
Okay. You may proceed with your argument.
Yes, Your Honor. I thought that I would begin by giving the court a very brief detail of the procedure that occurred in the legislature to establish that it was in fact all orderly, that it comported completely with due process, and that there are there cannot possibly be any questions about it. On February 28th, all the dates that I'm going to give, Your Honors, are in 2022. So on February 28th, the plaintiff, Mr. Payne, and Jane Doe, the complaining witness, excuse me, stayed at the Kings Alley Hotel in St. Croix. They were there on legislative business, and they were required to stay overnight. So they both, the legislature...
Orlando, unless you really want to use your time going through that, you know, we're familiar with the facts and we've read it, and you don't really have to spend time on that unless you want to, but your time is running.
Well, okay. It is all set forth in great detail in our main brief, as well as to some extent in our reply brief. In addition, the Committee on Ethical Conduct, the CEC, as it's referred to, issued a statement of alleged charges to Mr. Payne. He was represented by counsel. There were hearings, evidentiary hearings that took place. Counsel participated actively. He had the ability to call witnesses and cross-examine witnesses and so forth. And the net result was a decision by the 5 members of the CEC they found that there had been violations in 4 out of the 5 charges. Charge number 2 was not sustained, but charges 1 and 3 to 5 were sustained. The recommended penalty was a suspension. The suspensions were cumulative, so they totaled up to a total of 50 days, as well as a letter of reprimand. This resulted in a bill that was drafted, Bill 34-0287. It was presented in the legislature on July 19. On July 20, the full Senate convened for a full day of proceedings, I'm told, and the transcript of that full day of proceedings is in the supplemental appendix that we filed with the court at the time we filed our reply. Many other bills were considered and voted on. It wasn't just the Stephen Payne matter that was being considered, and some bills passed and some didn't, and some were referred back to committee and so on and so forth. The bill 34-0287 was amended and by amendment number 34-588 to provide that the penalty for the misconduct was expulsion, and that was voted on. Open vote on the floor. The vote was 14-1. The one vote against it was Stephen Payne. He was allowed to vote on the issue of his own expulsion. Okay. That was then sent to the governor, and the governor acknowledged receipt, and he sent it back to the legislature, and that also is contained, those documents are also contained in the supplemental appendix. The complaint, when it was filed, which was several days after, within a week or so after the expulsion, alleged due process violations. And this was in accordance with the arguments that were made by Mr. Payne's counsel during the hearings before the CEC. Mr. Moore had filed 2 memoranda, one in May and one in June. Copies of those are in volume 1 of our appendix, in which he argued various aspects of the matter, some evidentiary, but in which he raised, not in very great detail, but he did raise a due process argument of that the charges were overbroad and vague. In his complaint, he repeated that in paragraph 20 of his complaint. He also filed a motion for TRO and preliminary injunction and permanent injunction. At the very outset, the judge to whom this case was assigned, Judge Gums-Carty, had said in an order that what she understood the issue to be was a violation of Mr. Payne's due process rights under the Fifth Amendment to the U.S. Constitution. That was her understanding of what was being alleged, of what the problem was, as Mr. Payne had phrased it. And clearly, that is what I thought was being alleged in paragraph 20 of the complaint. A lot of people's eyes looked at this. Legal counsel for the legislature, the senators themselves, and as a result of that, I filed a motion to dismiss on, I believe it was August 10th, on behalf of Donna Fred Gregory, who had been properly served. I filed a similar motion to dismiss somewhat later.
Regarding your motion to dismiss, what did you base that motion on?
Well, we had 5 issues, 3 of which this court has ordered briefing on, and those 3 were speech or debate, the issue of whether or not the legislature is the sole judge of the elections and qualifications, and then Section 2B of the Revised Organic Act. We had 2 additional arguments. One was failure to join in.
Regarding the issue of whether the legislature is the sole judge of its qualifications, are you arguing then that this court must dismiss the case because only the legislature can judge those who are qualified to sit or those who are already sitting? Where do you draw that line, if you draw a line?
Both, Your Honor. The legislature is the sole arbiter, or the sole judge, actually the word that's used is judge, is the sole judge of the qualifications and the elections. So that gives them the right to, number one, exclude a potential senator, a person who has won the vote, but the potential to exclude them, not allow them to take the oath of office and therefore take a seat. And it also gives them the power later on to expel them.
Well, how do you square our precedent in this case? Sarah v. Fox, for example.
Which case, Judge?
Sarah, S-A-R-A-U-W v. Fox. How do you square this, the precedent of this court, with your argument?
I am familiar with that case, but I'm not, I've read the case. I'm not familiar with the holding that Your Honor is referring to.
In that case, we basically ruled that 6G did not bar us from deciding whether or not a person was a resident of the Virgin Islands and hence qualified to sit.
Yeah, and that's also the decision in Mapp versus Loetz by the Third Circuit. In Mapp, of course.
So, but my point is that their courts got involved. And you're saying, no, as I am understanding your argument, which is why I asked the question, you are saying, no, they cannot get involved, neither before nor after. That's what you just said.
I think that the guidance that was given by the Third Circuit in Mapp versus Loetz, and Mapp was a sort of hybrid case. It was an exclusion and it was an expulsion case. It was both, and both of those terms are used throughout the opinion. And in a footnote, the Third Circuit says, well, of course we can get involved if there is a sham or a fraud, a decision, an expulsion based on, that is alleged to be sham or based on fraud. But in that case, they said clearly this was fact-based. There was a tremendous amount of evidence to substantiate that Mr. Mapp, had given up his residency in the Virgin Islands. I believe he'd gone to Georgia and had established residency there.
So that was a qualification issue, correct? Whether he was a resident of the Virgin Islands?
Yeah, except that he'd already taken his seat. And so,
But still, it was a qualification. They decided afterwards that he wasn't qualified in the first instance. But in this case...
But they needed to expel him.
Was that?
But the remedy was an expulsion. They used the word expulsion and also removal.
But based that he was found to be unqualified to uphold office in the first place.
Yes, but there's a lot of discussion about expulsion, Your Honor.
In this case, there was no issues with qualifications.
No, there
He
were.
was sworn into office, he took the job, and was performing it. So you don't see a difference between expelling someone for conduct that occurred after being sworn in and conduct that would disqualify you before you even take office.
I think there is a difference, and I think that difference is recognized in Powell versus McCormick. Yes, Judge, there is a difference, no question about it. But I think that the language that provides that the legislature is the sole judge of the qualifications isn't necessarily limited to preceding or pre-taking the oath. It can also refer to the continuing qualifications of the senator. And would also like to draw the court's attention to the next phrase in in section 6G, after the phrase about the legislature being the sole judge, wherein the Revised Organic Act goes on to say that the legislature shall have and exercise all the authority and attributes inherent in legislative assemblies. And I guess I'm getting into my rebuttal here, but the court...
Getting into your rebuttal, you've passed your time already. You're over 3 minutes and 34 seconds, 24 seconds. So you reserved 7 minutes, so You took a lot of time just explaining the facts, which we already know. So you may have to wait until your rebuttal.
Shall I finish up now then, Judge?
Yes, please.
Okay.
Yes, you may.
All this body of given 3 assignments. And they were non-justiciability pursuant to 6G revised Organic Act and immunity pursuant to Section 2B of the revised Organic Act. Government passed the Tory 33 VIC section, in which it allowed itself to be sued under very limitations. So there is a right to sue. Under the Tort Claims Act, treated as a court use. The non-justiciability argument and it's a situation of the legislature not comport with the statutes, then you have to they have no right to expel. Under the revised Organic Act of 1954, they have a right to recall under Section 12C of that of the Organic Act. For a variety of reasons, it appears that recall is not a very popular remedy to implement, and it's the time limits involved. But recall is appropriate, and it's very appropriate.
Are you saying that the legislature never have the authority to expel someone?
That is correct, Your Honor, because it's an enumerated right given to the members of each House of Congress. It is not an enumerated right given to the legislature by the.
Is that a right that legislatures have had for going back to the British Parliament?
No, Your Honor. But here's the distinction. Congress has that enumerated right to expel under conditions. The states who existed before the United States existed have constitutions that give them particular enumerated rights.
You found any that has the right to expel?
Who's that?
Anywhere, either in the federal.
I think every state has the right to expel, but the territory of the.
But is it spelled out in the state laws or constitution?
It's in several.
Or is it something that has always been implicitly implied?
Your Honor, many of these states, I cited too a law review article. Each state that has its own constitution has basically taken on the 2/3 rule or the ability to expel its members of its elected body. They also have the ability to recall in many instances. But for the U.S. Virgin Islands, we didn't get the enumerated right to expel. We got the enumerated right to recall elected officials.
Well, Counselor, I have looked at Section 6 over and over and over. and I am reading it, and it says, the legislature shall be the sole judge of election and qualification of its members. One. And shall have and exercise all the authority and attributes inherent in the legislative assemblies. Legislative assemblies, whether you call them General Assembly, Senate, or whatever, they have been expelling people, expelling senators, expelling its members. And so when you said that even if in those states there's a constitutional provision in the state constitution, well, we don't have to have it here, because for all intents and purposes, this isn't 6G sufficiently broad to include expulsion?
No, I disagree, Your Honor. I was involved with MAP back then, and MAP did not meet the qualifications to be a senator.
Right. I understand that. I have an intimate familiarity with MAP, with MAP v. Lawetz. And I read the Appellate Division of District Court opinion and the Third Circuit opinion. But that again was a qualification thing. But what I'm saying is that in this broad language, and shall exercise all authorities and attributes inherent in a legislative assembly or assemblies, and shall have the power to initiate and conduct investigations, issue subpoenas to witnesses and other parties, blah, 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 blah. Well, isn't that language broad enough to cover expulsion?
Reconciling the rights of the voter. Voters selected who they wanted to be their senators. Wants to pass rules or up a club and a popularity
But
contest.
granted, do you know of any state legislature anywhere that don't have rules and regulations that govern the conduct of its members?
Every state has inherent sovereignty, because, as I said, states existed before the United States. And so they're able to do things that I submit. Broad general authority, but that broad general authority should not allow them to expel members, elected members, to that. That goes beyond the Organic Act. Spelling, I submit, is not an enumerated specific Congress and members of Congress.
Not enumerated, right, but in Mob v. Lawetz, was the Mob, he was expelled, am I correct?
That's
Yes.
poor use of the word, but it is correct, he was expelled.
Right.
He was expelled because he didn't meet the qualifications.
Right, so we cannot say that the legislature doesn't have any authority, that the Virgin Island legislature doesn't have the authority to expel. The Revised Organic Act is a federal statute that come under what? The Supremacy Clause. So, so it seems as if that once you have the Supremacy Clause and you have the Revised Organic Act of 1954 coming under that section, the Constitution and laws made in pursuant thereof, and the treaties shall be in that embodiment called the supreme law of the land. This is an integral part of that, which is the Revised Organic Act. It might be our Constitution, but it still takes precedent over just about anything else. So for all intents and purposes, and now we even talking about there's a move afoot to adopt the 1954 Revised Organic Act as our Constitution. But that's beside the point. What I need, what my point is that shall have and exercise all the authority or attributes inherent in the legislative assemblies. For all intents and purposes, that is very clear.
Your Honor, I understand that that is a very broad generalization of giving them the obvious, which is the rights to administer, conduct, make rules, and do things of that nature. And if we go back to 6G, when they talk about the qualifications, it's curiously joined with elections and qualifications. The idea is they're able to determine your into the legislature, the way in, but the way out, I submit, should be left
You
with
see
the
the
people.
section that you just read? What follows after that part that says election and qualification of the members?
The part that you've been talking
Right,
about.
shall have and. So it's a tripartite thing. The qualification, it should be the sole judge of the judges of the election, the qualification, and shall exercise such other powers and that is inherent in a legislative assemblies. If they didn't have that, we can't just limit it to the election and the qualification, because anything else that comes up that reflect adversely or disrupt the Virgin Island legislature would be powerless if they don't rely on that. They may have the recall provision and so forth and so on, but that's an extensive process. The legislature, as I said here, shall have and exercise all the authorities and attributes inherent.
How do you not use all parts of the Organic Act?
Yes, well, what happens, all right, this one here is specific.
This one is general, and it's general to say how you get into the legislature. The election and the qualifications, that's up to the legislature. But how they remove a senator is also part of the revised Organic Act. It's a 12C, and under that section they say recall. And the recall terms are listed, and you can't make up new reasons to recall. They are specific and statutorily listed. Just like the qualifications for a senator. You can't change them around. They're specific and set by the revised Organic Act of 1954. So on the way in, I don't have any qualms with the legislature saying this person's qualified or this person's not qualified.
Okay, let's assume that the legislature has the inherent authority under that provision that you can, all inherent rights in assemblies. Let's assume that they have that right, and an expulsion is part of the right. Just assume that. Tell me why enactment of the recall provision somehow displaces that, or why isn't it complementary?
6G is general, 12C is specific.
Well, but you see, you're not accepting what I have said. Assume that inherent in the legislature's authority that is generally provided to assemblies is the right to expel a member for violating the rules. If that has been in place forever and is inherent here, why would enactment of the recall provision somehow repeal that authority that legislatures have had for years?
Your Honor, I regard the recall authority as a way that the Congress in its administration.
And that's why, in a way, it's not inconsistent with the provision, the power to expel. Because the recall provision, for one thing, is very limited. You've got like 9 months to do it. You can't bring it within the first year, and you can't bring it within the last 3 months. So how does that, if a member were to commit bribery or something um, right after taking office, the legislature would have to let that person be in place for a whole year before it could be recalled. So aren't they inconsistent, really?
Your Honor, I regard them as not being inconsistent, but I also regard the efforts of to expel a senator is something that doesn't require the participation of the electorate to put the senator there.
Well, let me
So-
see if
so
I understand you
with-
correctly. What you are simply saying is that any time that we have a senator that does something, commits a crime, do anything that's inconsistent with the ethics and the conduct of the legislative body, that the only recourse that they would have is a recall provision?
Your Honor, I acknowledged early in my presentation that there were timing problems that made recall unpopular to use because it's hardly ever, I won't.
Well,
No,
with
it's not a matter whether it's
but there, what you're arguing is that there are that the legislature can punish, can prescribe any punishment other than expulsion.
That's exactly
That's
what.
your argument.
That's it.
And you're also arguing that's because the Organic Act that has not enumerated that power, has not given that power to the legislature.
Congress did not give that specific enumerated right and power to our legislature.
And there's no room there for an inherent right to govern its own affairs and make sure that its members obey its rules, that the people's business is conducted.
Justice Brett, they have management, administrative. Off committees or fine them or suspend them or whatever, but they can't expel them. That's what I'm trying to say. The only way out of the legislature was by recall. And if you want to take and expand it to where any senator who's been duly elected by the people of the Virgin Islands from that legislature, just by their vote.
So your argument, I mean, if I take your argument to its logical extension, your argument is that Congress intended not to give that right to the legislature because it knew that, it knew that Congress has the right to expel its own members, and it knew it's a right that has existed since colonial times. It was aware of that right, but left it out? Is that your argument?
Said what? I didn't hear that.
Deliberate.
Not to include the ability to expel a senator.
So your argument lives or dies on your determination that the legislature does not have the authority under the Organic Act to expel a member.
I think that's fairly stated, Your Honor.
For any reason.
They have to have some standard. Qualifications is listed, that's a standard, enumerated. Have to have some reason to be able to throw them out of the legislature, and those are specifically enumerated under the recall statute.
There's a plethora of reasons as to why the legislator would feel as if that a sitting senator would have to be expelled. And under your provision, it seems as if that the only thing that they're able to do, if it doesn't have to do with the election or the qualification, then you have to go to recall.
I'd say that's fairly stated.
Totally oblivious to the other section of Section 8, Section 6G.
No, not oblivious. They're allowed to do many things within their authority under 6. I'm submitting to this court that one thing that they're not allowed to do is dismiss someone without an enumerated standard. And qualifications on the front
How
end.
long would the list be? Let's just suppose Congress said, we're gonna make absolutely certain that under the revised Organic Act that we will list those reasons only, what you call enumerated reasons, as to why someone could be expelled. My God, how long would the list be?
Qualifications, because those are
Well,
specifically.
qualification and judge of the election is very short. But what I am hearing is that you're saying that the legislature could be innumerable reasons, a plethora of reasons as to why somebody deserves to be expelled from the legislature. But the legislature can't expel them because they have to go to the recall provision, because we can ignore all that other section that says that the legislature shall exercise the authority and attributes inherent in a legislative assembly. You know why they didn't have to enumerate it? Because all they have to do is look at case law precedent across the country and see all the reasons possibly in which people have been expelled.
Your Honor, the reality of the situation is expelling someone from the legislature is voters are at 4, Section 4. I think it shows the significance and the obligation to provide us with a Republican form of government, that we heed the wishes of the voters. And if the voters want someone to be elected to the legislature, it should be the voters under recall who would take them out.
But that in some way, what you're saying is that, and listen to what it is that you're saying. What you're saying is that when the voters go to the poll and they're voting, suppose subsequently there is conduct made by a senator at the legislature, sitting senator and so forth and so on, that never came up before, that was not in existence at the time of voting him in. You're saying that only the voters, by way of a recall, can take him out? And all this time, suppose if he's a disruptive element, the legislature have to sit there, endure anything and everything that this person does, because the only how they can get rid of him is for the voters to go to recall him. Once he's elected and he goes within that body, then he accepts the rules and regulation of that body, provided, of course, that is not in violation of the Constitution or any laws or anybody's constitutional rights. But what you're saying is that almost like once a person is elected, and the persons that have to deal with him every day are members of the legislature, any kind of misconduct and so forth and so on, that the legislature have to live with that person there, whether a disruptive element or not, because you can only get him out by a recall, because the voters have to recall. Are the voters going to be studying all of that in terms of recall?
The Ethics Committee listed some sanctions for Mr. Payne. Those were completely within its dominion authority. But they did not list, the only way they have out of the Senate is because that is something between the legislature and the voters.
Do they have the right to suspend him?
They would have the right to suspend him. They
And
would
is
not.
Is that one of the enumerated?
Pardon?
Is that enumerated in the Organic Act?
No, it is not.
So
It is not, but they have, I'm saying that generalization from 6G allows all the administrative responsibility have within its own house. But to expel is something I just
you see,
think.
if your argument the legislature could suspend him for 13 months, which would go beyond his term, without pay. But you're saying that'll be okay, but you can't expel him.
You know what I did? I also brought up the fact that they are under the ROA obliged to pay him. That's one of his rights, his contractual rights by
Well, let me
being
ask
elected.
you, since let's go back to 2B. You're aware of any case law that says that there is a contract between a public official and the government?
No,
In
but
fact,
this would be a.
the
this
Supreme
would be a-
Court specifically ruled that there is no contract between a public official and the government with respect to salary for holding that office. Didn't the Supreme Court specifically hold that?
I believe you can, because you can compare any of their rules to any part of the revised Organic
But
Act.
if you can't have a contractual relationship as a public official with the government, wouldn't your claim strictly be under the torts?
It could be under the Tort Claims Act, yes, that's correct. And if
Under the Tort Claims Act, did you do anything? Did you file a notice of intent to sue?
No.
Let me ask you one thing before. You've gone over a lot, so I'm going to allow the appellant to have a little more time since you've gone over 10 minutes beyond your time. So,
Your Honor, I
the
spent the time
legislature
answering
moved,
questions.
the
sir.
legislature moved that we should depublish, we should strike and depublish the opinion that was issued after this court assumed jurisdiction. You did not respond to that. Do you have any position on that?
That
They asked, apparently, the court below issued an opinion.
memorandum
after-
opinion,
Yeah,
after you had.
after this court assumed jurisdiction, so. They've asked that be depublished. In other words, it's published on the website. They want us to take it down and treat it as a nullity, and it can never be cited as authority for anything. You did not respond to that motion. What's your position on that?
Your Honor, I didn't respond because when the court took jurisdiction away from the Superior Court, consequence, I love the memorandum opinion that the court below issued. I was careful not to quote from it because I didn't want to be plagiarizing. How other judges are approaching or looking at this. Not respond because there was nothing for me to respond to since this court took over jurisdiction.
Okay. One other thing, wouldn't you be asking us for this court to substitute its opinion for the 14 senators that voted to expel him? And wouldn't that be interfering with the internal operations of the legislature?
Not if it ran afoul of provisions of the revised Organic Act. If they use their rules, and their rules, all of its sections, it's a broad cloth. It's not like you can pick this. Comprehensive plan. And so if you look at it that way, anytime the rules of the legislature run afoul of this comprehensive plan for civil government, right to punish, they have the right to administer. I only say they don't.
Thank you. You reserve 7 minutes, so I'm going to give you an additional time. So.
Thank you very much.
7 minutes here, Judge.
No, I'm gonna give you 12 minutes.
Your Honor, I want to start by both addressing,
Bring it down some so you can speak right into it, and
Is
and I
this
know
better?
you got a stronger voice than that, you know. Speak up so we can,
yes, Your Honor.
right. Everybody in the back of the court wants to hear you.
Thank you, Your Honor. I want to start by addressing both something that Mr. Moore said and something that Justice Swan brought up, and that is, Attorney Moore says that it is enumerated power. It would be an enumerated provision, that is to say, the power to expel. And my question is, what's his authority for that? What says that it is an enumerated power? And to tie in with something the Chief Justice said, well, what about suspensions? And what about other forms of discipline? None of those are enumerated. Who gets to say what needs to be enumerated and what's not? And what I'm hearing from the other side, apparently, is Mr. Moore thinks that, you know, he's in a position to say
No,
that.
he is saying that because of the recall provision, that should be the sole provision. Is what he's argued in his brief all along.
I understand, and as Your Honor pointed out, it could be considered complementary. So what is the authority, statutory authority, case law authority, treatise, law review? What says that it has to be an enumerated power? Our position is, as I think I made it very clear in my reply brief, is that the power to expel is an inherent power. And this is something that Justice Swan was picking up. I would like to quote, if I may, very briefly from a provision of a case that I cited in our reply brief. It's called Montserrat versus New York State Senate. I'm quoting from the district court opinion, 695 Fed Sup, 2nd, page 80. The case did go up to the Second Circuit, and it was affirmed there. But in the district court opinion, they quote at page 91 of the Fed Sup site from Joseph Story's Commentaries on the Constitution of the United States. No person can doubt the propriety of the provision authorizing each house to determine the rules of its own proceedings. If the power did not exist, it would be utterly impracticable to transact the business of the nation, either at all or at least with decency, deliberation, and order. The humblest assembly of men is understood to possess the power, and it would be absurd to deprive the councils of the nation of a like authority. But the power to make rules would be nugatory unless it was coupled with a power to punish for disorderly behavior or disobedience of those rules. That appears at page 91. Also at page 91, the district court in a string cite cites to many different cases which provide for the power of expulsion. I disagree with my colleague, Mr. Moore. He said, if I understood him correctly, that all the states have the power to expel in their constitutions. That is not so. Very surprisingly, New York did not have that, and New York being one of the original colonies, one of the original 13 colonies. As of 2010, when this case was decided, Montserrat, they did not have that. I don't know if they've since added that, but at the time of this decision, they did not have it, and that was one of the issues that was raised. Mr. Montserrat had been a state senator, and he was expelled, and he raised that as an issue, that the Senate in New York did not have the authority to expel him because it wasn't in the state constitution, as it was in the state constitutions of many, many of the states. And to advert for just a minute to the decision of Judge Gumbs-Carty, which I did move to vacate, she says at page 29 that there are 7 states that do not have that provision in their state constitution. She goes on to only list 6 states. I don't know what happened to the 7th state, but New York was one of the 6 states that she listed. And so naturally I went to New York because it's a very large state, and I figured it had the most case, it was likely to have the most case law. And sure enough,
By citing that to us, are you asking us to consider that opinion?
No, I'm just referring as a factual matter, the statement, it was not a holding, Judge, just the statement that there are states that do not have that provision in the state constitution. The other state that I found that does not have that in their constitution, or at least not at the time, was also one of the original 13 colonies, and that was Massachusetts. And that case is HISS, H-I-S-S versus Bartlett. It appears at 69, Massachusetts reports 468. Again, we cited it in our reply brief. I want to discuss a little bit more about the Monsanto case. The court reviews what went on in front of the Senate, and it ends the discussion by saying that the Senate had justified the expulsion on the grounds that what Mr. Montserrat had done severely damaged, I believe that was a domestic violence charge that had been lodged against him, severely damaged the institution's honor, dignity, integrity, and public reputation. And they considered those to be a very important consideration which justified what the Senate had done. I want to draw the court's attention to what the findings of the CEC were. And in those findings, at the last...
Well, you know, I don't know that you need to tell us all of that, but one of the arguments they make is that the legislature acted irrationally when it simply amended the resolution, the bill that was on the floor for a 50-week or 50 days, whatever it was, suspension, and put in expulsion instead. And that was an arbitrary and capricious act. That's a little different from what you are telling us. So can you tell us why the legislature, having gone through the committee and decided to suspend him, and he obviously accepted that, and when it came on the floor, there was a motion to amend, which surprisingly he did not object to, and the amendment was accepted without any opposition. And a vote was then taken, 14-1. And if all of a sudden he has gone through the process, a decision was made, a recommendation was made, and then it was suddenly changed on the floor from suspension to expulsion. And I think that's one of his biggest arguments, that the legislature acted ultra-vires, so to speak.
Well, Your Honor, I would like to answer that, but I did not understand that to be his argument. His argument is that there's no power of expulsion. So whether it was done earlier or later or in committee.
In his brief, he also says that it was arbitrary and capricious to simply amend it on the floor without really giving him due process. Isn't that, you didn't understand that to be a part of his brief?
I understood he had a more absolutist approach, which is what it seemed to be at this oral argument.
But he also argued as well that the legislature, and not, even giving notice that they intended to increase it, other than when they produced the amendment, just simply changed, two words basically, suspension to expulsion, and that somehow that deprived him of his rights.
Just like in any case, there's two elements. There's liability and damages. I think that the full Senate adopted the report in full in terms of the liability, meaning that the findings of the CEC with respect to the misconduct was adopted by the full legislature. The issue then became one of sanctions, and for that misconduct. And the recommendation, as Your Honor notes, it was 50 days plus a letter of reprimand. And so the question is then, really, from a legal point of view, was there anything preventing them, and by the way, the CEC made it clear in their various letters and communications that what they were doing were recommendations. In other words, there were recommendations on the liability aspect, and there were recommendations on the penalty aspect. And so, and that ultimately the decision was for the full Senate. So this was done on the floor of the Senate, and an open proceeding that was transcribed and done in due course. And the full legislature took a different view, Your Honor, as they're entitled to do. They run their House.
Well, what would have occurred if Mr. Payne had objected?
I think what would have happened is that it would have opened it up to debate.
And what would have been debated? The sanction?
Yes,
Amendment?
yes, presumably.
Changing the sanction from 50 days to expulsion?
I think Mr. Payne was free to debate anything, so if he had wished to debate the misconduct aspect of it, the finding of misconduct, I think he would have been free to have done that because, as I said, both aspects were merely recommendations by the CEC. So I think he would have been free to have debated both aspects of it. But he didn't, and as they say, the rest is history. It went for a vote, and it was unanimous. I note under Rule 814, it requires a 2/3 vote for an expulsion. And if you recall from Mapp versus Loetz, there was a lot of discussion. A lot of what Mr. Mapp was arguing was that the vote to expel him had not been 2/3; it had been 9 in favor of expulsion. And of course, to get to 2/3, you needed 10. And the court the Third Circuit in a footnote discusses. It was called Rule 813 back then. It's 814 now. That it required 2/3 vote. But they never hesitated about the idea that that an expulsion was something that could be done. I'd also like to draw.
Let me ask you this, Counselor. You know, in the MAP case, one of the huge arguments that MAP was saying is that, the rules call for X, right? The rule called for you can't get rid of me because you didn't meet the threshold number. Because
2/3.
he was saying that it has to be what I think he was saying that it was 2/3.
2/3.
Not a majority.
Yeah.
And they're saying no. The switch on him at the last minute, which is what has happened here. They are switching from a suspension to an expulsion. But MAP had raised that issue. That was one of the things that the late Julio Brady
He litigated it furiously, Judge. He litigated it to kingdom come.
They didn't give him much of the time of day.
The Third Circuit took the position.
Legislature changed the rule. Because the legislature is its own rule-making body.
Yes, it is.
Period.
Yeah.
And if they feel as if that, well, even if we had the 2/3 rule in place when we started these proceedings at the legislature to get him out, because I'd given him a hearing, but they switched on him and they said, no, it's no longer that, it's now this. And that seemed to have been perfectly well with the appellate division of the district court and the Third Circuit. And that's why he's out.
Yes.
But but one of the beef in the opinion of the territorial court judge was that the legislature did not meet the threshold of their own rule. I remember that all too well. You know why?
I don't know why, Judge.
I know it all too well.
I'm hoping you'll tell me.
Anyway, I noticed that they never mentioned who was the territorial court judge in the MAP decision done at that level. But anyway, that's water under the bridge. But they vociferously argued that they couldn't get me out, even though he never necessarily said that they were not the sole judge of the election and the qualification. What he was on the main thrust of his argument, according to the late Julio Brady, is that, well, you don't have the numbers to get me out, therefore you can't expel me.
Yeah.
And because you didn't meet the 2/3 threshold. That was changed on him during at the last minute. the same thing here in which it changed the rule.
Yeah, and I think the word judge, when in the phrase sole judge, is used advisedly. And it may be counterintuitive to this court. It may not feel right because this court is used to judging, right? That's what you do. You judge. But they judge on stuff that comes before them. They're the judges. And I think they, you know,
But if it
they didn't
violates-
use the word arbiter.
If it violates a constitutional provision or a legal principle, this court can say what the law is, correct?
I agree, and that goes to the Third Circuit's footnote in MAP that says if it's a sham or a
Absolutely,
fraud.
because at that point
Okay.
in time, anytime it's a violation of the Constitution or laws and so forth, then you rarely get into, you are no longer into the fair of what they call separation of powers.
Yeah,
That's what all of the decision, whether it's avoiding Bronx versus Hanson, whether it's MAP
No,
or
I agree-
whether-
I agree, Judge.
whoever it was.
I agree.
They said that once you get into the issue, you know, the legislature can do a whole lot of things, but once it get into violation of the Constitution, a federal statute such as our Revised Organic Act or other laws, then it's a game changer at that point in time. Can't do it. So separation of power principle go out the door, but it stays in for all other purposes.
Attorney Arellano, under the speech and debate clause immunity, where it says no member shall be held responsible. Does that cover the legislature as a body?
yes, Your Honor. We addressed that in our reply brief. The Supreme Court of Virginia versus Consumer Union decision. It's a 1980 U.S. Supreme Court decision. In that case, the Virginia Supreme Court had been sued.
We're familiar with it.
Okay, and
But let me ask you
what the
this,
U.S.
though.
Supreme Court said is they were operating in
But
legislative.
that was common law immunity, and you never pled a common law immunity. You know?
You argued 6D.
Yes. And
6D states that no member shall, no member of the legislature shall.
Yes.
That's the,
The question is, does it cover
shall
the...
be held to answer.
Right.
It doesn't say the members of the legislature.
it doesn't say the legislature.
Correct.
Yes, I agree. But the Supreme Court has held that the concept is expansive enough or elastic enough to include the legislature because it included the Virginia Supreme Court.
You know, it's really amazing because in the United States Constitution talk about speech and debate. In our Revised Organic Act, they never talk about speech and debate as such, but we use what they call immunity. They are granted immunity, and it is forwarded back to for any speech or debate.
I think that's the caption, isn't it?
Yeah.
I think that's the caption of that section. I think it says immunity.
Right.
I believe it uses the phrase immunity or the word immunity.
Immunity of
So
members.
they don't call it. So they don't call it speech and debate. They call it immunity. Immunize them.
But the United States
For
Supreme
speech
Court
and debate.
has held that it is, in effect, an immunity not only from liability, but from the duty of having to defend oneself at a trial. And that going through a trial would itself be a violation of that immunity in those areas where speech or debate would apply. I must make one more point, Judge. I hope you'll indulge me if you give me 60 seconds more. I realize I'm a little bit behind on my time. But I wanted to draw the court's attention to the other cases that we cited in the brief, and particularly the case of French versus Senate of the State of California. It is a 1905 case. Now, in that case, in California, they did have a provision in the state constitution which allowed for expulsion. But the Supreme Court of California said, you know, we would have that anyway, even if it wasn't there. And when I read this, it opened my eyes. It's a whole new way of looking at things, Your Honor. What the Supreme Court of California says is the reason why they put it in state constitutions is because they say, and it's in the United States Constitution as well as in the state constitutions of many of the states, it says an expulsion is by 2/3 vote. And so that the provision is not a grant of power, it's a limit of power. It is limiting an expulsion to a 2/3 vote. It's a requirement. It's a new floor, a new threshold. You got to have a 2/3 vote. Because if the provision wasn't there,
Do
they
you
would
know
have
of
it
any
anyway.
case that have held that a legislative body don't have that authority to expel?
I know of no case that holds that a legislative body cannot expel.
That's what I asked you.
Yeah, I do not know of any case. And the cases that I found where it's not in the state constitution, the courts hold that it's an inherent power. I want to make one more point, if I may, please. The Hiss versus Bartlett case, the Massachusetts case, which I had referenced a little earlier and which is cited in our brief. The argument was that there shouldn't be an expulsion. It should be by way, the senator should be kicked out by way of an impeachment. And the court said that that would be slow, laborious, and expensive, and inadequate to the object sought to be obtained. So that those were proper considerations for the court. And I make that argument with respect to recall. I don't think we need to defend the issue on recall, but since it's been the subject of so much discussion, as the Chief Justice pointed out, it's not available during the first year. And not only is it not available during the last 3 months, but from the point of the recall, it cannot be initiated earlier than 30 days nor later than 60
But your
days.
opponent concedes that timing problem.
Yeah, well, it could not have been done in this case because assuming we start from the July 20th date and we say it cannot start for 30 days at the earliest, if everything worked perfectly, then that's August 20th. August 20th is less than 3 months from the election in November, right? It would have to be August 5th or 4th or 6th, somewhere in there like that. So August 20th was already too late, and that was the earliest that it could have been done. So that means legislature's hands are tied. And I go back to Joseph Story, and I go back to Montserrat. You cannot have an organization of men, a council, a legislative assembly that has its hands tied, that cannot do anything about a member who is guilty of misconduct.
Okay, thank you.
Thank you very much, Your Honor.
The matter will be submitted.
Your order said that we're going to do all of this, and then
Well, I mean, we have a rule that says if something comes to your attention after the hearing, that you can alert the court and, let a brief or something.
very well.
You anticipate? Do you anticipate having something else to add?
Not, well, actually, I was just maybe asking for more time, but never got.
Well,
Yeah. Okay, thank you both. The matter is submitted.